Good morning, everyone. My name is Reghu Ram. Welcome to Lukmaan IAS. Today we are going to discuss the polity section of the All India Pre-Mock Test 1. I hope you have enjoyed the paper and the questions. We have tried to mix the static portion with the current developments, and we hope that we have satisfied the demands of the recent UPSC trend through the framing of the questions and the nature of questions. So without much delay, let us directly go to the questions. Question number 6. Consider the following statements in the context of Narcotic Drugs and Psychotropic Substance NDPS Act 1985. You must be very much well aware of the NDPS Act, especially when the son of a famous Bollywood actor has been arrested and sent to jail by the NCB, Narcotics Control Bureau. Later, this individual was acquitted or discharged because of lack of evidence. And there are many other issues also dealing with NDPS because the stringency of the Act NDPS. Section 37 of NDPS is always in the news because of the stringent condition for bail. As you know, in general criminal laws, the principle is bail is the norm and jail is the exception. This principle gets reversed in the context of special penal laws including NDPS, PMLA, UAP, etc. So section 37 of NDPS deals with stringent conditions of bail. So a person who is accused under various sections of NDPS will only get bail when the magistrate, when the judge thinks that, in fact, when the magistrate reasonably believes that the individual is not guilty. Second, the magistrate should also reasonably believe that the individual will not commit crime in future. So how the judge can conclude that he will not commit the crime again if set on bail? The conditions are very stringent. That is the reason there have been multiple demands that this condition, that the stringent nature of NDPS needs to be made more human right oriented. It must be made more flexible. Although you know that drug trafficking and the linkage between drug trafficking and organized crime are very much problematic. So the stringency of NDPS is given because to address these problems. However, let us not go into that debate at this point in time, but keep in mind section 37. Another important terminology that comes into the mind is the terminology known as conscious possession. You must have also come across this word, conscious possession. This is again a terminology, a phrase used in the context of that Aryan Khan case. Because Aryan Khan did not possess the drug. It was his friend who possessed it. Still, the person is accused of having something called conscious possession. Consciousness means the awareness of a fact. So, Aryan Khan knows that the person had the drugs and he had that drug because both of them can consume. So this is a kind of vicarious liability or responsibility. Anyway, the conscious possession also has importance to safeguard individuals' right. How? It has been accused that the investigative agencies planned the drugs or the psychotropic substances in individuals so that they can be arrested. Or let's say, if somebody has given you some packet in order to and asked you that please take this packet and give to that individual. You do not know what is inside that packet. But if you are intercepted by the police or the NCB. And if they open that packet and it is found that there are drugs in it, but then he will say, I did not know that they were drugs. Right? So, whether you knew, whether you have consciousness of that possession, what exactly is in it. So, by applying conscious possession, you can be charged as well as you can be discharged. Because if you can prove that you did not know that this was drug and you did not have awareness of that. So conscious possession and section 37, these are very important as far as NDPS is concerned. And as you know, NDPS, it is a parliamentary law. NDPS, Department of Revenue, Ministry of Finance is the administering authority of NDPS. NDPS Act provides for a central authority established by the central government, which is the Narcotics Control Bureau. So, Narcotics Control Bureau is the central authority that exercises power under NDPS. NCB is an institution, an organization working under Ministry of Finance. NDPS is administered by, NCB is under MHA, Ministry of Home Affairs. But NDPS is administered by Ministry of Finance. There is another institution under this NDPS Act which is known as let us first discuss that, then we will come to that. Consider the following statement in the context of NDPS Act 1985. The Act completely prohibits the cultivation of opium, poppy or any cannabis plant in India. Second, both the central and state governments have the authority to add or omit name of substance from the list of psychotropic substances. As per the Act, the seized sample of the contraband should be duly certified by the gazetted officer to qualify as evidence in the court of law. How many of the above statements are correct? The answer is D, none. Why is it so? The Act completely prohibits. No, it does not completely prohibit. In fact, the federal government can authorize the cultivation of opium or poppy for medicinal purposes. There is an authority in Gwalior which functions under the Department of Revenue. Right? So that authority grants permission. The authority's seat is Gwalior. Hence, the first statement is incorrect. Second, both the central and state governments have the authority to add or omit the name of substance. Only the central government has the power to add or omit. Right? So the statement 2 is also incorrect. As per the Act, the seized sample of the contraband should be duly certified by the gazetted officer. You see, the problem here is that if something is confiscated, some material has been taken from me, and if it is to be certified by the gazetted officer, which means the executive authority, let's say the police officer himself, or maybe an SDM or an executive magistrate, all these people belong to the executive branch of the government. So it is very much possible that they may misuse that authority. Even if drugs are not recovered from your possession, they may certify that it is drugs. So that is the reason separation is required. Hence, it is not a gazetted officer, it is actually a magistrate, a judge, the judicial branch of the government, in order to safeguard the rights, liberty of individuals. Right? So the answer is D, none. Let's go to the next. Consider the following statements in the context of remote voting. Yes, this is an important issue. In fact, many of you have attended the editorial discussion that I have taken as far as the remote voting is concerned. You must know that the Election Commission of India has proposed that they are ready for doing or conducting remote voting. Even they proposed something called remote voting machine. They also requested the political parties to give their views. Some political parties have given their views, some have not given. They have outrightly rejected this remote voting machine or RVM proposal of the Election Commission of India. Why they have refused is a different matter altogether. But anyway, as of today, the debate seems to have reached to a point because we hardly see any important development with respect to RVM. But keep in mind, today or tomorrow, because the election is going to happen, this debate will also come again. So let us go to the question. Consider the following statements in the context of remote voting. Statement number 1, it will address the issue of migration-induced disenfranchisement of voters. Yes, the major problem is that when migrants, when they go, because their voter ID or their name is in the electoral roll of their home state. Let's say people going from north to south, from West Bengal to Kerala, from Jharkhand to Kerala, from Bihar to Tamil Nadu, from Bihar to Maharashtra. So during election they cannot go back to cast their vote because that will be financially disadvantageous. Election Commission of India data shows that large number of migrants are not able to vote because of the issue. So remote voting might help them because they don't have to travel. So disenfranchisement, which means the incapacity to vote. So it will address, definitely it will address. Statement number 1 is correct. It will help registered voters to exercise their constitutional right. Now the issue is this, whether right to vote is a statutory right, fundamental right, constitutional right or not. If you remember the question of UPSC 2017, if I am not wrong, the right to vote and to get elected is which type of right? They have given some options, constitutional, fundamental, legal, etc. The UPSC has given that option as, the answer as constitutional right. Yes, they have given that option as constitutional right. The terminology is important. Right to vote and to be elected. If this question comes again, mark it as constitutional right because UPSC has given the key. But keep in mind, right to vote is neither a fundamental right, not a constitutional right, is a statutory right or also known as legal right. Number of judgments of the Supreme Court have made this very much clear. Right? There is a 5-judge bench of the Supreme Court. Kuldeep Nair case 2006. So Kuldeep Nair case 2006. Kuldeep Nair case 2006. Supreme Court has the 5-judge bench of the Supreme Court said right to vote is not a constitutional right. And even before that, number of judgments have been there which have upheld, which have said that, which have given the conclusion that right to vote is statutory right or a legal right. Right? So the reason we have put this question, this statement here is also because of the debate that has been going on. Because if you know the Election Commission of India judgment, Anup Baranwal versus Union of India, where the Supreme Court has provided for a collegium type of appointment as far as the ECI is concerned, there the judges expressed their view that the right to vote should be a constitutional right, or even some judges have also recommended that or observed that these are they should be fundamental rights too. But they were not part of the judgment per se, which means that the authoritative pronouncement of the earlier benches of the Supreme Court stands, which means right to vote is a statutory right. Right to vote and to be elected is a constitutional right as per the UPSC. Right? Remote voting solution may enhance people's participation in the election. Absolutely, this is a very simple statement, isn't it? People's participation. Now, if the more number of people vote, more number of participation. Very absolutely correct. Simple. What is the answer here? Answer is, this statement is incorrect. Answer will be 1 and 3 are correct. So option B is the answer. Let's go next. Consider the following statement. Statement number 1. NALSA was established to promote an inclusive legal system in order to ensure fair and meaningful justice to the marginalized and disadvantaged sections of the society. Statement 2. Article 39A of the Constitution of India provides that state shall provide free legal aid. NALSA is an important institution. If you see 2023 mains examination 2, they have asked in the 10 marker. And there have been multiple development initiatives taken by the government as well as the Supreme Court and various other legal service authorities to promote access to justice and free legal aid to the poor and vulnerable section of society. Right. So NALSA was established to promote inclusive legal system. Absolutely correct. Statement 1 is absolutely correct. Don't need to explain this. Yes, free and competent legal aid is one of the objective of NALSA. Legal Service Authority Act provides for the establishment of NALSA. NALSA is the central authority at the union level, whose patron in chief is the Chief Justice of India. Executive Chairman is the senior most judge or a retired judge of the Supreme Court. Right? Statement number 2, Article 39A of the Constitution of India provides that states shall provide free legal aid. Yes. So Article 39A of the Constitution, DPSP, right? 42nd Amendment Act provides that the state shall take steps in order to provide free and competent legal aid. So, by virtue of this DPSP, this NALSA was established. Both statement 1 and 2 are correct, and statement 2 is the correct explanation for statement 1. Yes, because DPSP is the directive to the state to take some action. 39A says you should provide free and competent legal aid. So, in order to fulfill that directive, the government has come up with LSA under which NALSA was established. Right? Option A is the correct answer. 9. Which of the following is the most appropriate meaning of doctrine of parens patriae? You see, you might file this as difficult. It's acceptable, and you may not choose to answer this question too, because the most of the options are framed in such a way that you may think, if you do not know, that anyone can be the answer. Why we have taken this question? Because of the current developments. Recently, the Supreme Court has made the wife of an individual as the guardian of that individual. Individual means because her husband is in a comatose condition and unable to take any decision. So, the Supreme Court has made the wife the guardian of that individual, because on behalf of that individual, that person, on behalf of her husband, she will take all decisions. This is one. And in fact, if you see the Kerala High Court, the Kerala High Court has used this doctrine of parens patriae to provide a name to a newborn child, because the husband and wife are having a lot of issues, matrimonial discourse, right? So the court has taken the responsibility under the parens patriae to give a name to that newborn. So what exactly parens patriae mean? Parens patriae mean father of a country, or father of, or parent, not father, parent of a country, parent of a fatherland, which means there are multiple individuals in the society who may not be able to take decisions for themselves. Children, disabled, those individuals having mental disabilities, people in vegetative comatose conditions, people even if they have all the faculties, but they are incapable because of the socio-economic disadvantages or financial incapacity. Here the state, the government will come into picture, and the government will take decision on behalf of them. This is the idea behind parens patriae, because parents are the decision makers as far as their children are concerned. Here the children are unable to take decision, parents are taking. But what about in a situation, hypothetically speaking, orphans, who will take decision? The state has to take decision. Because if you see the philosophical basis of this, why the state came into existence? The social contract theory, if you see, state came in order to protect the life, liberty, rights for people. So government is the instrument of exercising the sovereignty, the power of the state. And government has various organs, executive, legislature, and the judiciary. So the executive and the judiciary in general, they take decisions. So the two examples which I have provided, who has taken? The court has taken. The government can also take decisions. In fact, the parens patriae is also majorly, progressively being applied to those multiple areas, environment, pollution. And this can also apply in the context of climate change. Ultimately, this means that vulnerable sections, poor individuals, who are unable to take care of themselves. The state has a responsibility to take care of them. That's the idea behind it. The state is empowered to provide care to citizens who are unable to care for themselves. Absolutely correct. If you know the concept, you will be able to answer the question. UPSC require conceptual understanding. Rote learning will not help. Right? Parents have the legal responsibility to make medical decision in the best interest of their minor children who lack decision-making capacity. This is not dealing with parents' battery. Provides elderly parents every legal right to make their own decision and not dependent on their children. Factually correct statement, but not in the context of the question. Children have the legal responsibility to make medical decision in the best interest of the older parents who lack decision-making capacity. May or may not be. But anyway, that's not related with the question. So answer is A. In the context of the President of India, which of the following statement is incorrect? President of India. Impeachment of the President is a quasi-judicial function of the Parliament. The President can be impeached only for the violation of the Constitution. The Constitution explicitly defines violation of the Constitution for the purpose of the impeachment. Impeachment charges against the President can be initiated by the Rajya Sabha. Incorrect is the option. Always keep in mind, read the question number of times. One thumb rule is, if you know the answer, read the question twice. If you do not know the answer, read the question thrice. Reading the question, understanding it, reading the command, choosing the option is very much important. Many of time it happens that individuals, students in the examination hall, even after knowing the answer, they choose wrong option. Why? Puzzlement, tension, unable to control emotions in the examination hall, poor reading. Don't do that. Read the command properly. Incorrect. What is incorrect here? Impeachment of the President is a quasi-judicial function. Yes, impeachment, quasi-judicial function of the Parliament, because Parliament act as a judicial act in a judicial capacity when the impeachment proceeding is going on, because Parliament decides, investigate, examine the charges and pronounce of decision. So Parliament is doing an adjudication duty instead of legislation. What is quasi-judicial? Quasi-judicial body or quasi-judicial function. What does it mean? Judicial functions carried out by authorities outside the ordinary court system. Quasi-judicial. An administrative body carrying out judicial function. What is judicial function? Essential judicial function is adjudication. Hearing the evidence. Hearing the parties. Looking at the evidence. Passing a recent order. A speaking order. Likha hua. Adjudication. President can be impeached only for the violation. Yes, President can be impeached only for the violation of the Constitution. Article 51 of the Constitution says so. Does it explicitly define? No. Violation of the Constitution has not been defined in the Constitution nor in any law. Right? So, this statement is incorrect. Impeachment charges against President can be initiated by Rajya Sabha. Yes, it can be initiated by either house of the Parliament. One house initiates, other house investigates. As you know, 1/4 of the total membership is required. 14 days notice required. After that, the resolution has to be passed by 2/3 members of the total membership. The highest majority in the context of special majority is required as far as president is concerned. Right? No president has been impeached so far. You see, USA, even impeachment charges is being framed against Biden. Earlier it was framed against Trump also, and one house has passed that impeachment motion. But the way impeachment is done in USA is different from the way it is done in India. Next, 51. Consider following statements about the Deputy Speaker of the Lok Sabha. Deputy Speaker. Why this question? Deputy Speaker is an important functionary. UPSC has asked number of times. And as you know that in the 17th Lok Sabha, which is ongoing Lok Sabha, no Deputy Speaker has been elected. Right? The Constitution says that as soon as the House assembles, the House will choose a speaker and deputy speaker as soon as possible. So as soon as possible is the word. So as soon as possible should not be more than 4 years, isn't it? But anyway, there is no deputy speaker as far as the 17th Lok Sabha is concerned. But deputy speaker is a very important functionary. He or she is nominated by the speaker of the Lok Sabha, no, in consultation with the president. He is elected or she is elected, not nominated. Statement 1 is incorrect. He or she cannot perform the functions of the office of speaker when it is vacant. Incorrect. He or she can perform. When the speaker office is vacant, deputy speaker will function. When deputy speaker is also vacant along with speaker, then who will function? President will appoint. Vacancy is different from absent. Vacancy means nobody is holding that post. Like deputy speaker post is vacant in the 17th Lok Sabha. Speaker nahi hai. Deputy speaker bhi vacant hai. Then who will? President will appoint. If the speaker post is also vacant, deputy speaker is also vacant, president will appoint an individual to carry out the functioning of to preside over the meeting or deliberation of the house, the Lok Sabha. If these people are absent, then you know that the panel of chairpersons, they will conduct the proceeding. But when it is vacant, panel of chairpersons cannot come. Correct? He or she cannot preside over the joint sitting of the House of the Parliament. Joint sitting of the House. Keep this in mind, Article 108 and 118 of the Constitution, along with rules of the House and rules made by the President in consultation with the Council of the Chairman of Rajya Sabha and the Speaker will govern the joint sitting. So 108, 118 and the rules made by the President in consultation with the Chairman of Rajya Sabha and the Speaker of the House will govern the modalities, procedures with respect to joint sitting. The Constitution says joint sitting will be presided over by the Speaker. In his absence, who will preside? You will say Deputy Speaker. You will say after that Deputy Chairman of Rajya Sabha. Fine, but keep this in mind, the Constitution only says that Speaker will preside over joint sitting. In the absence of the Speaker, the rules which were made earlier by the President in consultation with the Chairman as well as Speaker will decide. According to these rules, in the absence of the Speaker, Deputy Speaker, after Deputy Speaker, Deputy Chairman, and if Deputy Chairman is also not there, then the houses will decide that who should be presiding over joint sitting. This is how it goes. Nominated, incorrect. Cannot perform, incorrect. He, she cannot preside over the joint sitting of the House of the Parliament, incorrect. Answer is D. (52) Consider the following statements. Pre-legislative review, pre-legislative scrutiny, all these things are all similar ideas, right? So, let's go to the question. Pre-legislative review is a process where a bill is scrutinized by the political branches of government prior to enactment to assess its constitutionality or rights compliance. Let's go to the next statement. This review ensures better protection for constitutional rights than standalone judicial review. Examination by a parliamentary committee is an informal way of pre-legislative review. What is this pre-legislative review? Before a law is made, as you know that every law should be conforming to the Constitution. A law violating the Constitution will be struck down. Struck down by who? The Constitutional Court, the High Court or the Supreme Court. So, a law making is a very tedious, complicated, time-taking process. And a law is made in order to address a problem or in order to provide rights to people. So, when a law is made, it should be ensured that the law is in conformity with the Constitution, it does not violate right of the people, and it should also not violate the judgment of the Supreme Court. In fact, it should not be struck down under the purview of judicial review. So in order to make a law, a legislation foolproof, compliant, easily implementable, simple, easily understandable, review is required. So this review, as you know that whenever a bill is generally made, a draft is given. A draft is given. This draft also given to the public opinion, and this draft is also a product of the ministry. The ministries having interaction, discussion, ministries, cabinet committees, the bureaucracy, and the Ministry of Law and Justice is always there. They interact, they discuss, they communicate, and they scrutinize. This is the process. They review that draft, they review that bill, whether it is required or not. For instance, let us take the example of the Digital Personal Data Bill or Digital Personal Data Act. Now it is an act. As we know that the draft has been given, later it has been given to the Parliamentary Committee, Joint Parliamentary Committee. They have discussed. Again, they went to the Parliament. So, political branch of the government, we mean the legislature and the executive. Within executive, multiple ministries. Within executive, cabinet, council of ministers. Within legislature, the Parliament, Lok Sabha, Rajya Sabha, committees, Senate committee, this committee, that committee. So, they scrutinize it. Why scrutiny is required? In order to assess the constitutionality, mean whether it is violate the constitution or not, whether it is in line with the fundamental rights, will it stand in the code of law, 103rd Amendment Act, if you remember. What is that? Let us take the GST. 101. Let us take the 106th Amendment Act, the recent one, Women's Reservation Act. So it has followed a procedure. The EWF Amendment, 103rd. Pre-legislative review is a process where a bill is scrutinized by the political branches of the government prior to enactment. Absolutely correct. Number 2, pre-legislative review ensures better protection for constitutional rights than standard judicial review. Absolutely. Because in judicial review, what happens is that 1 or 2 judges, they examine everything. Few lawyers come and discuss. That's it. But when there is discussion, debate in the parliament, in the committees, it's a broad-based, wide-ranging discussion. Right? So it will protect, in theory, it can protect, safeguard, promote the rights of individuals. Because there are meeting of minds of large number of people, multiple viewpoints, multiple opinions, multiple perspectives can be given, unlike in a judicial review. Examination by parliamentary committees in an informal way. No, this is the catch here. It's a formal way. Right? Because the parliamentary committees, they draw their authority from the constitution as well as the rules. So it's a formal way of doing it. And if you have, and you know that one of the important functions of the parliamentary committee is to scrutinize the legislation, scrutinize the bill, and recommend changes. Right? So statement 3 is incorrect. How many of above given statements are correct? 1 and 2 are correct. So option B is the answer. Consider the following statements. Statement 1. A petitioner is entitled to relief under a curative petition even if he is not a party to the litigation, but the judgment adversely affected his interest. Statement 2. A curative petition is the final remedy available where the Supreme Court can reconsider a dismissed review petition. Curative. What does that mean? Curative means to cure. To cure a remedy. As we know that if the petition is dismissed by the Supreme Court, or let's say if some judgment is given which you feel that is against your, interest, then you can file a review petition, which is given in the Constitution. What about after review? Even after review, you feel that or you believe that some injustice has been done to you. then there is no avenue earlier. But the Supreme Court has innovated this mechanism of curative petition. When a review is dismissed, you can file curative under some condition. For instance, natural justice is not adhered to. I am impacted by the judgment, but I am not being called. My position is not heard. My concerns are not heard. There is biasness, etc., etc. So, curative petition. Hura and Hura judgment is the one which has given to the concept of curative petition. So, this petition, even if it's not a part of litigation, but the judgment adversely affected the interest. If the judgment affects my interest adversely, I am not a party to the case, but the judgment is given in such a way that it has adversely impacted my interest. So, I can file a curative petition. If this petition is the final remedy available, when a review is dismissed, final remedy. Now, statement 1 and 2 are correct. But this is not the right explanation of that. This does not explain this. A curative petition is the final remedy available where the Supreme Court can reconsider dismissed review petition. It simply explains what is a curative petition, what is the purpose of it. I mean, when you can use it. It is a description of curative petition. It's a different statement altogether. So this does not explain it. Both the statements are correct, but statement 2 is not the correct explanation. The correct explanation would be the fundamental principle behind judicial review or adjudication is natural justice. If that is the case, then this would have been the correct explanation. Because I am not heard, I am not a party, but impacted my interest. Right? So before taking a decision which affects my interest, I should be heard. My position should be heard. I should be given an opportunity to present my case. Next. Consider the following: State Election Commission, State Finance Commission, DPS, DPC, reservation of seats for women in Gram Panchayat. How many of the above given were provided by the 73rd Amendment Act 1992? Very easy question. But one catch is here. Keep in mind DPC and MPC are given and are instituted or are incorporated into the Constitution as per 74th Amendment. District Planning Committee is given under the chapter Municipalities. So, Municipality is 74th Amendment. So, answer kya hai? SEC, SFC both are given in Panchayat and Municipalities. DPC is given only where? 74th. Reservation of seats for women, Gram Panchayat, 73rd. Gram Panchayat, very easy. DPC, District Planning Committee. Composition manner will be determined by state legislature by law. However, the Constitution provides that 4/5 of the members of DPC will be elected from the elected members of the district panchayat and also the elected members of the municipality falling within the area of the district according to the population of, according to the ratio of rural population to urban population. Keep this in mind. 4/5, 54, 55. Consider the following. The Constitution makes it mandatory for the states to reform their respective preference laws according to Model Preference Act. Very important because you know that the Model Preference Act has been promulgated by the, I won't use the word promulgated. Model Preference Act has been enacted by the, I won't also use the word enacted. The best word to use is the Ministry of Home Affairs recently has, yes, let us use the word enacted. The Parliament has enacted this Model Preference Act 2023. This Model Preference Act is an important one because as you know that the Preference Act as of today is a colonial legacy. Some amendments have been done on that, but still the purpose of the Preference Act, the colonial, the current Preference Act is to keep individuals in custody, to punish them than to reform them. So reformative, restorative aspect of the prison is missing from the colonial act which we are following. So that is the reason this Model Preference Act, a reformative attempt by the MHA, Ministry of Home Affairs, in order to decolonize the elements of the provision within the Act, in order to provide for reforms. Because ultimately, when you keep individuals in prison, what is the purpose? Is it retribution? One of the important modern day purpose of keeping people in prison is to reform their character, to enable them to integrate within the larger society. This aspect is missing from the current Prison Act, so Model Preference Act. Now, how is that Model Preference Act and Constitution? This is a very easy statement to understand. Can the Constitution, will the Constitution provide something for Model Preference Act? Have you come across this anywhere? Seems to be a very illogical statement, very easy. And if you know that prison is something which is under state list, prison is a state list subject, Schedule 7, List 2. So the state will have power over the management and administration of prisons. So Model Preference Act is something enacted or promulgated by the central government, by the union. How it can be that it can the Constitution says that the act enacted by the union on a list which falls under, on an item which falls under the state list should be mandatorily adopted by the state government. Where is federalism? Where is distribution of legislative power? If you apply your mind, then definitely you will be able to solve this question. Very easy. Statement number 1 is incorrect. Schedule 7, preference is a subject under state absolutely correct statement. Statement 2 is correct. Statement 1 is incorrect. क्या answer है? Statement 1 is incorrect, but statement 2 is correct. It's model because whatever happens is that whenever some subject falls under the list 2, state list, the parliament cannot make a law unless in those exceptional conditions. In generally, they cannot make law. They cannot make law and ask the state to implement it. That is the reason model. As you know, Model Preference Act, Model Land Reforms Act, Model AIPMT Act. Because the states can adopt them according to their needs. That's the idea behind model. It's a model which others can adopt. The union cannot force them to adopt it because the subject in which the law is made falls under the state list. 56. Consider the following pairs. Present day law. Very difficult to pronounce maybe. But as you know that the IPC, CRPC and IEA, Indian Evidence Act, are being replaced by a new set of laws. As you know, the Parliamentary Standing Committee, which Parliamentary Standing Committee? Parliamentary Standing Committee on Home Affairs is examining this bill. The today's news is that the Parliamentary this committee which has examined this bill, these bills have held their report because some members have given their dissent notes, etc. Very important development which is happening. But anyway, we are simply asked to match this. Now, the Code of Criminal Procedure 1973, Bharatiya Nyaya Sanhita Bill 2023, Indian Penal Code, Bharatiya Nagarik Suraksha Sanhita, Indian Evidence Act, Bharatiya Sakshya Bill. Those from South India might have some difficulties in pronouncing this because this is the language is somewhat difficult for them. But anyway, we are not going to that debate or any debate. But yes, UPSC sees the country as a whole, right? There is no south or north, west or east. We need to study everything, right? Everything in the sense as per the syllabus is concerned. So let us match this. Present day law amendment bills. Code of Criminal Procedure. This criminal procedure is not this one. This is Bharatiya Nagarik Suraksha Sanhita Bill. So CRPC will be replaced by this bill. BNSS. कैसे याद करें? Very easy. Criminal, Nagarik. So link criminal with Nagarik. Criminal, Nagarik. Citizens, criminal. Penal Code. Penal. The purpose of penalty, punishment is to provide न्याय, justice to people. तो कहां पर न्याय है? Penal Code. न्याय संहिता. Very easy. Code. इंडियन पिनल कोड, न्याय संहिता. तो ये दोनों गलत है. All these two are incorrectly matched. Evidence Act, साक्ष्य, साक्ष्य, साक्षी, the sakshi. You can link this evidence. Statement 3 is correct. This is very. There are many progressive elements under the amendment bills because there is a provision for criminalizing marital rape, provision of let's say death sentence for mob lynching. Right. There are and also technology used, making greater use of technology as far as investigation is concerned, etc. However, there are also challenges and weaknesses, criticism as far as this bill is concerned. Anyway, so answer kya hai? Only 3. So only 1 is the answer. 57. Consider the following constitutional amendment acts: 61st Amendment Act 1989, 73rd Amendment Act 1992, 74th Amendment Act 1992. How many of the above given constitutional amendment acts required the ratification by the state legislatures as per Article 358 of the Constitution of India? Amendment to the Constitution, very important to know. 368 provides for 2 types of amendment. One is a majority of 2/3 members, a majority of 2/3 of the total members of the House, and a majority of total membership of the House. This is one. Second, first condition, the 2/3 of the total majority, 2/3 of the, no, this is like this. 358 provides for 2 types of majority. Number 1, a majority of 2/3 members, a majority of 2/3 of the total membership of the House present and voting, and a majority of total membership of the House. These 2 conditions will be fulfilled. 2/3 members of the House present and voting, and a majority of total members. Some amendments can be done through this procedure, but those amendments which affect the federal relations in this country need to have consent or assent, concurrence of the state legislature too. Remember, which one? GST. Remember, 106th Amendment Act, Women Reservation. At least 50% of the states. At least 50% of the states through simple majority. If they pass, then the amendment can be valid. 73rd and 74th Amendment, you already know that because local government is in the state list. That is the reason it required state consent. 61st Amendment, as you know, it has reduced the age from 21 to 18. So, it has also impacted the representation of the states in the Lok Sabha. In fact, it has changed the composition of representation. This also required the consent of at least half of the state legislatures. So, kya answer hai? All the 3 are correct. Our answer is C. Special majority. As per 358, 2 kinds. Number 1, a majority of 2/3 members of the House present and voting, and a majority of total membership of the House. Second, number 1 fulfilled, and at least 50% of the states consent through simple majority. Right? 58. Consider the following statements. Charge sheet. We wanted to have a question dealing with pure law aspect because, as you know, the question dealing with prison, right? Police custody, judicial custody, UPSC have the habit of asking recently. So we wanted to have some question related to specifically dealing with that legal aspect, law. The charge sheet is a police record containing the name and identity of the person along with the nature of the accusations. A charge sheet submitted by the agency is a public document. The charge sheet as a public document does not violate the rights of the accused but infringes the rights of the victim. Recently, a petition was filed in the Supreme Court by a journalist, Saurav Das. In Saurav Das versus Union of India, the Supreme Court has dealt with the issue of charge sheet because the individual wanted that charge sheet should be given to be uploaded in the portal so that the public can access it. He also wanted that it should be given in RTI. But the Supreme Court rejected this petition. He said that It's not a public document. If it is published, it is given, charge sheet is given to the public, then the rights of the individual, as well as the victim, as well as the complainant will be violated. The identity, the nature of crime, everything. So the right to the privacy of the individuals, both the victim as well as the complainant, the victim as well as the accused, will be violated. The Supreme Court rejected the petition. That is the context in which we framed it. Charge sheet, as you know, it's a comprehensive document that a agency, a police or CBI or for that matter ED, whoever that might be, gives to the court. उसके अंदर क्या होगा? Crime क्या है? What are the charges? How the investigation is done? Who are accused, detained, arrested, evidence, everything everything will be given in the charge sheet. And order before charge sheet, trial will commence. Anyway, so first statement is correct. Second, public document. The court said not a public document, which means that it will be available for the complainant, that is the victim, accused, and the investigation agency and the court and other prosecutors, etc. No, it's not a public document. Everybody cannot access it. Charge sheet as a public document does not violate rights of the accused, but infringes the rights of the victim. It violates the rights of both accused as well as victim that we have discussed. So, क्या answer है? Answer is only one. Correct पूछा है? Yes, statements are correct. Only one. Answer is A. 59. Consider the following. Increase in the size of provincial council. Introduction of communal representation. Enlarge the deliberative functions of the provincial legislative council. How many of the above given provisions were introduced by the Morley-Minto Reform 1909? Government of India Act and various acts, the Regulating Act, Charter Acts. These things are very important because generally you get one question either in polity or in history. That's the reason we have given one question here. 1909. You need to revise the points, the provision under the acts multiple times so that it will remain in your mind. All the three statements are correct. This 1909 Act or Morley-Minto Reform this Act under the Morley-Minto Reform provided for first time what? Communal representation. Provided for representation for Muslims. And it also provided for class representation. How class? Zamindars, Presidency Corporation, etc. It also increased the number of seats in the federal level, Federal Legislative Council, Imperial Legislative Council, and also increased in the Provincial Legislative Council. Right? So, statement 1 is correct, communal representation correct, deliberative function of the council, deliberative function. Ultimately, what is the function of legislature? Deliberation, discussion, debate. So, if there are more debates, then the executive, the government, the colonial government will be in problem. So, but the individuals, the Indians are freedom movement is demanding, give us power, parliamentary form of government, let the council control the government. So, slowly, by each subsequent act, the colonial government has increased the deliberative function of the council. Statement 1 is correct. Statement 3 is correct. Enlarge the deliberative function of the council, the provincial legislative council. क्या answer है? All of the above. Answer is C. The rule of law index is released by which of the following organization? Similar type of questions are asked by UPSC also in previous years. Very important because number of indices are there. Freedom, the status of freedom, press freedom report, democracy index, corruption perception index, etc., etc. So keep a tab on these developments, and also find out some important component under this index. What are the bases in which these indices are formed? Recently, as you know, Global Hunger Index, and the government has said that the methodology is wrong. So the indices are very much important. So the current affairs should be very much aware of that. Rule of Law Index. कौन है? World Justice Project is the non-profit organization which releases Rule of Law Index. right? All the other have their own different reports. Transparency International, as you know, Corruption Perception Index, CPI. Freedom House, as you know, that it deals with the status of freedom in the world. Right? Human Rights Index, Human Rights First Resource and NPO, which examines, studies the status of human rights across the world. But anyway, it's there's a Rule of Law Index is released by World Justice Project. Right? So that is it as far as polity is concerned. Right? And I hope you like those questions. And whatever doubts you have, you can ask us. We'll be definitely reverting back. And to attempt polity questions, what is required is clarity of concepts. Along with that, what is required is revision. Along with that, what is required is a proper understanding of the current development. Right? Okay then, thank you so much. All the best.